Well, hey there, and welcome back to Heimler's History. Now, we've been going through Unit 3 of the AP Government Curriculum, and in this video, it's time to talk about the constitutional right to privacy. So if you're ready to get them brain cows milked implicitly, then let's get to it. So in this video, here's what we're trying to do. Explain the extent to which states are limited by the Due Process Clause from infringing upon individual rights. Now, the operative word in that learning objective is states. How are states limited from infringing upon individual rights? Remember, we've been talking about the process of selective incorporation, which is how the Supreme Court has applied the protections of the Bill of Rights to the states. And they're able to do that because of the Equal Protection Clause of the 14th Amendment, which says, "No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor deny to any person within its jurisdiction the equal protection of the law." So this is an amendment mandating protection of citizens' civil liberties from state intrusion, not federal intrusion. Okay, let's talk about the constitutional right to privacy. And already you're like, I don't remember that being in the Bill of Rights. And you would be absolutely correct. Nowhere does it say in the first 10 amendments to the Constitution that Americans have the right to privacy. Right to the free exercise of religion? Yes. Right to a speedy trial? Yes. Right to privacy? What you talking about, Willis? It's true, there is no such right explicitly mentioned in the Bill of Rights. However, in the course of several Supreme Court cases, the court established the right to privacy as an implicit right based on the 1st, 4th, 5th, 9th, and 14th Amendments. So let me explain. In 1925, a case called Pierce v. Society of Sisters was decided. This is a non-required case, but it's important nonetheless. It was a case about Oregon's compulsory education law, which meant that parents had to send their children to a public school in their district. A couple of Catholic parochial schools saw their attendance dwindle as a result of that law and said that such a law was unconstitutional because it took decisions about education out of the hands of parents. The court agreed with the parochial schools, and in his majority opinion, Justice McReynolds said this: "The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." So this case is important because in general, many scholars argue that it was this decision that set the stage for the court's interpretation for the right to privacy. However, it was 40 years later in a case called Griswold v. Connecticut that the right to privacy was clearly established by the court. In that case, the court ruled that a married couple could not be denied contraceptive medication. In other words, the government could not infringe upon a married couple's right to privacy in making decisions about their health. And it was Justice William Douglas who authored the majority opinion, and in it he said these famous words: "The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras," which means shadows, formed by emanations from those guarantees that help give them life and sustenance. Various guarantees create zones of privacy. So Douglas uses the metaphor of light and shadow to explain how the Bill of Rights works. There are rights explicitly stated, and those are clear because the light is cast on them and they are plain for all to see. But those rights also cast shadows, and those shadows are zones of privacy that correspond to the enumerated right mentioned specifically. Now, I understand it's a little confusing, so let me just give you an example. So the First Amendment protects a person's right to the freedom of speech, and in a previous case, the court determined that this right extended to what a person possesses and chooses to read. So when a Georgia man was arrested in the late 60s for possessing pornographic material in his home, which was illegal in those days, the case came before the Supreme Court. And in a unanimous opinion, Justice Thurgood Marshall wrote this: "If the First Amendment means anything, it means that the state has no business telling a man sitting alone in his own house what books he may read or what films he may watch. Our whole constitutional heritage rebels at the thought of giving government the power to control men's minds." Okay, so the right to privacy, even as a shadow of other constitutional liberties, had been well established by that point. And that brings us to the most controversial of all right to privacy cases, namely Roe v. Wade in 1972. Now, as with all your required cases, I have a whole video diving into the details of this case, so here I'm just going to give you the basics. When a woman identified as Jane Roe could not obtain an abortion under restrictive Texas laws, she appealed to the Supreme Court arguing that her rights had been infringed upon. The court agreed and ended up overturning abortion laws throughout the United States, and in the majority opinion, the justices argued like this: "A state may properly assert important interest in safeguarding health, maintaining medical standards, and in protecting potential life. At some point in pregnancy, these respective interests become sufficiently compelling to sustain regulation of the factors that govern the abortion decision. We therefore conclude that the right of personal privacy includes the abortion decision, but that this right is not unqualified and must be considered against important state interests in regulation." Now, there are two things to notice here. First is that a woman's right to abortion is based on her constitutional right to privacy, and in the decision, both the Pierce and Griswold cases were called upon for precedence. However, as with every other liberty protected in the Bill of Rights, this right is not absolute. At some point, and the court calls this point viability, a pregnant woman, according according to the court, has an actual human being in her belly. And at that point, the woman's right to privacy may in fact be tempered by the state's interest in upholding the life of the child. For the court, that meant that before the age of viability, which is to say the first trimester, states could not in any way restrict abortion. In the second trimester, states could make restrictions as long as they were related to the mother's health. And by the third trimester, states could prohibit abortions entirely unless the mother's health and life were at stake. And so I probably don't have to tell you that this case created a firestorm among American citizens, and it still divides us to this day. Even so, with this case and all the cases that came before it, a citizen's right to privacy as the penumbra of the explicitly mentioned liberties in the Bill of Rights has been well established. Okay, thanks for watching. Click right here to grab a review packet, which is going to help you get an A in your class and a 5 on your exam in May. And since you have a well-established right to privacy, I will in no way tell you what to do, but if you want me to keep making these videos, then you can let me know that by subscribing, and I shall oblige. Heimler out.